Government Oversight meeting. We have a joint meeting today. We're pleased to have representatives from the Department of Administrative Services, 3 guests. One will offer opening remarks for us. We welcome Director Mike Carroll. Following his remarks, and I'm hoping each of the members has received the handout provided by the agency, then we will have opportunity to have discussion. So at this point, we call the meeting to order and would ask the clerk to call the roll, starting with the Senate.
Senator Peterson? Here. Senator Shane John?
Here.
Senator Garrett?
Here.
Senator Reiner? Present. Senator McCoy?
Present.
House?
Representative Kester?
Here.
Representative Hartsville?
Here.
Representative Gaines?
Here.
Representative Bosler?
Here.
Representative Cummings? Representative Lansing?
Present.
Representative Murphy?
Yo.
Representative Pettingill?
Here.
Representative Peete?
Here.
Thank you, all present. Next order of business is the minutes that were electronically distributed from our last joint meeting was February 6th. If there be no objections,
Yes,
comment. Representative Murphy.
correction. It's been almost 2 months since we've met jointly, but in the meeting on February 6th, I specifically requested that we have the ombudsman in to address the Toledo issue, and all we received is an email from Ruth Cooperrider, the ombudswoman, since that's what she is. But we have not had that done. That's been almost 60 days. I would like to have that reflected in the minutes that I asked for that. That has not occurred, and I would like that to be reflected in the minutes.
Very good. So noted. Those will be in the minutes today, as well as if we approve, we will reapprove those at the next meeting. And as a quick update, the co-chairs have met and exchanged emails both with Ruth Ann Cooperrider of that agency and have distributed a recent report germane to that very request as recent as yesterday. But we will reconvene with her, has been the consensus of the chairs. Thank you for the question.
We still need to approve our minutes from yesterday.
Next order of business would be the Senate meeting of April 2. Representative Peterson.
The minutes of yesterday's Senate Oversight Committee were distributed electronically. Any corrections to those minutes? Seeing none, they'll stand approved.
Next order of business would be the House meeting from yesterday. The minutes from the meeting that ended in this room last night were distributed electronically last night and to all parties by morning, both chambers. Are there any objections to approving them as sent electronically? Seeing none, those minutes are approved. Thank you. Following the opening remarks from our guests from the Department of Administrative Services, I'll then share a process for discussion that the co-chairs have agreed to. The members only will be invited. The members of the Joint Government Oversight Committee will be the ones to ask questions of our guests at that time, and we'll share a protocol just prior to beginning the discussion. At this time, we'd like to recognize Deputy Mike Carroll. Welcome to the meeting. Director Carroll.
Thank you very much. Members of the Joint Oversight Committee, I'd like to thank you for this opportunity to meet and clarify the settlement agreement and the terms relating to confidentiality and non-disclosure included in them. I certainly welcome the chance to answer your questions and clarify the actual facts involved. I made a mistake by allowing the confidentiality clauses to be included in those agreements. They did not align with the governor's commitment to open, transparent government, and they should not have been allowed as a part of terms of any settlement agreement. The governor has taken the leadership opportunity and issued his Executive Order 85, making the use of these clauses, which were a systemic practice in both this and past administrations, illegal moving forward, and I will not allow confidentiality clauses in settlement agreements in the future. The governor and lieutenant governor knew nothing about the terms and conditions within these settlement agreements, as the authority for the execution of those agreements was vested in the Department of Administrative Services. in past administrations and until the Department of Administrative Services changed the policy in 2012. Authority to enter into and execute these agreements was vested in the individual labor relations specialist handling the grievance resolution procedure. In 2012, the policy was changed to move that authority to my office with my approval to better manage the process and continuity of how settlements were being handled. These agreements were never secret, but as a matter of Iowa law, public record and available to the citizens of Iowa at any time. All the public, including the Des Moines Register, needed to do to obtain copies of the agreements was to ask via a FOIA request. Some of these payments were made out of the operational budgets of the departments involved because they did not qualify for payment through the appeals board out of the general fund. Those qualifications require the monies paid out be either back wages from a prior fiscal year or that the amounts be in excess of what the department has within its operating budget. Neither of these qualifications apply to the agreements in question. The payments made to individuals as a result of these agreements were not hush money, but in settlement of specific grievances filed by each individual as stated on the face of every agreement. I'm sorry for not recognizing the fact that these confidentiality clauses were not in compliance with the Governor's Transparent Government Initiatives, and it will not happen again. I would encourage this body to join with the Governor to help change the law to make all terms and conditions of those agreements public information by supporting House File 2462. I assure you of my assistance in making that happen. I am very proud of the changes the Department of Administrative Services has made to the reorganization of the design and construction area. This reorganization and operational improvements have resulted in an annual operational savings of $730,000 and to date has eliminated millions of more dollars in claims for time and money on state construction projects. If this trend continues for the current volume of $376 million in state construction, the savings will be over $12 million. These results are definitely in compliance with the Governor's goal of a more efficient, cost-effective state government saving taxpayer dollars. I will answer any questions that I can regarding this situation. Thank you.
Thank you, Director Carroll, for your handout, for your revealing statement. As we embark on the discussion, we would start with the Senate and alternate between Senate and House. The questions to be directed to the Department of Administrative Services, and we have a timekeeper that'll do a courteous indicator. If one of our questions happens to hit the 5-minute mark, we certainly understand there may be a follow-up to the original question, but we'd like to offer the flow to go back and forth. No respect of party, but respect of each chamber having an alternating opportunity to speak. And we'd start with the Senate.
But we'll clarify if there's time within the 2-hour block, we'll go back to people who have additional.
Oh, indeed. There's no limit of one time to be directing questions.
Senator McCoy needs to go.
And we'll begin with Senator McCoy.
Thank you, Director Carroll. It's good to have you here today. Before we start with the substance of the material before us, I'd like to ask a couple questions. The committee asked you to be with us last week. We had scheduled Oversight Committee. It's my understanding that you were out of state on business. Is that correct?
I was out of town. I wasn't out of the state.
You were out of town on business. What was the nature of the business, if I may ask?
Sure. I'm a member of the Engineering College Industry Advisory Council at Iowa State University. That meets twice a year, and those meetings were scheduled for Thursday evening and Friday. And I had 2 meetings. I also serve on the Outreach and Diversity Subcommittee, and I had 2 meetings with regard to that the afternoon prior to the evening meeting on Thursdays.
Okay, I was, I guess, a little surprised because the Oversight Committee had requested and scheduled the meeting and asked you to attend, and I was surprised to find that not only yourself, but also Mr. Woodley and Mr. Carlson were unavailable last week, and I just wanted to get a better understanding of where your other department heads were that week while you were out of the office.
I don't know. I don't keep track of the schedule necessarily, but that's where I was.
Okay. If we could just move to the question of the confidentiality agreements, keeping in mind this is limited time, I'd like to ask you some questions, and I'd prefer just to do yes or no. You indicated in your opening statement that neither the governor nor the lieutenant governor knew anything about the confidentiality agreements. Is that correct?
That's correct.
Okay. And the other people that I wanted to ask if they knew about the confidentiality agreements were Brenna Finley,
No.
Jeff Point,
No.
Dave Roeder.
No.
Did anyone at the Department of Management below Dave Roeder know?
No. Not to my knowledge.
So nobody knew about the spending at DOM in these confidentiality agreements?
I would assume they could have looked into the spending. I don't know whether they knew or not. I thought the question was with regard to the confidentiality clauses.
The question, I guess the question is about the confidentiality clause, and specifically referring to the pay for silence in the clause.
First of all, Senator, there was no pay for silence in any of these agreements. That's a complete misinterpretation of what any of this was. But all of the settlements were for specific grievances filed by individuals as stated on the face of those agreements.
The governor's office indicated that they felt that these clauses or these secret payments were disappointing and Iowans deserved better. To quote the governor, he came back from his spring break trip and immediately issued an executive order, almost as fast as it took the House to pass a piece of legislation yesterday to try to resolve this issue. My question is, do you believe that these confidentiality agreements were wrong?
I believe it was wrong to include them in our agreements because they did not comply with the governor's initiatives on transparent government.
Who advised you to include them?
During the settlement agreements, I had a number of people advising me. I had legal counsel advising me.
Who was your legal counsel?
Ryan Lamb.
Ryan Lamb advised you to include them into the overall agreement?
We talked about a lot of things in those agreements. It was ultimately my responsibility whether to include them or not.
But you're telling me that Ryan Lamb made, on advice of counsel, you included them?
No. I'm saying that I made the final decision whether to include them or not.
But you sought counsel through Ryan Lamb?
He would have told me if I shouldn't have or not. Yes.
And he told you they were appropriate?
They were appropriate given the systemic practice in past administrations and this administration. The problem was I did not realize that they were not in compliance with the governor's transparent government. I should not have allowed them to be included, and that was my mistake.
You do not believe these agreements violated state law?
No.
Do you believe that today?
Yes.
Excuse
me. Since the executive order, I don't believe that. But up to the executive order, they did not violate state law.
Did you seek advice to the Attorney General as to that?
Yes.
And what was that advice?
The advice was that they do not violate state law.
When was that advice given, and in what form?
We've had memos from them. We've had verbal discussions with them.
Can you
They
produce those
in
memos,
fact have drafted some settlement agreements themselves that include confidentiality statements.
Can you produce those memos for us, please?
Sure.
Thank you.
Forgive the interruption, Senator.
I'm out of time.
Well, I want you to finish the point you're on, you haven't exceeded the 5 minutes.
No, I want to stop because if I'm out of time, I'm out of time.
Okay.
Thank you.
Thank you.
Chair recognizes Representative Murphy.
Thank you. The first question I would have is, you agree, based on what you said, you believe the confidentiality requirement is not legal, And you're saying that the testimony that was given yesterday, then you waive all confidentiality in those contracts with anybody that signed one of those?
I believe my comment was that I think the confidentiality agreement or confidentiality clauses included in those agreements at the time, prior to the executive order, were legal.
And as the director, are you saying that you will waive those so that any person that had a confidentiality clause can come forward now?
Actually, there's a question as to whether they're enforceable or not whether they're legal or not.
But I'm just asking if you'll waive that as the director and the person that signed those
If
contracts.
that's a legal decision, someone else would have to advise them.
But Mr. Carroll, if you signed them and we have people that spoke yesterday, why wouldn't we just waive it for anybody that hasn't so that they want to speak, they can come forward?
I would have no problem with that.
And so as the director, are you saying that you would waive that so that they can speak here in the future if they choose to?
I'd be happy to.
Thank you. I guess the next question I have for you is, there are like 3 questions, and you can take as much time as you need for them. Some of it you may have discussed, but some of it's also for the committee, for us to understand. I guess the first one is, what did you know and what did the governor know, and when they knew it, is I guess the first question I have. And before you answer that, one of the things that I'm going to make as a motion here on the Oversight Committee is to also ask for a FOIA of your agency to do that, so that we can check emails as well. So I would like to know when you knew, when you were doing these confidentiality agreements, when the timelines that they occurred, and when other people in the executive branch, other than yourself, in the governor's office, whether it was chief of staff or whoever, knew that these were occurring.
And the second part of that was a FOIA request for what specific?
FOIA request for information, namely emails, that would actually, that we could actually look at and request as part of the Oversight Committee.
I respectfully request that you put that request in writing just so I understand
That's fine.
it perfectly.
That's
so
fine.
If we do that, we'd be more than happy to do that.
Okay.
First of all, the governor, lieutenant governor, or their office knew nothing about the terms and conditions within these settlement agreements. The first time they would have known those terms and conditions probably would have been the day after the Des Moines Register article came out. It was never policy or practice that settlement agreements went to the level of the governor's office. That was vested in the Department of Administration, has been for administrations past. It doesn't surprise me that the governor's office would not know the specifics within a settlement agreement. They may have been aware that settlements were taking place, but with regard to the specifics within those agreements and the clauses within those agreements, there would have been no reason why they would have known that or should have known that based on past practice and policy.
I assume the agency directors were aware of that.
Many of them could have been, yes.
But you're saying you don't know if the agency directors, so if I was the head of a division and we had a person that left state government and there was a confidentiality settlement agreement, you're telling me that I may not have known about it?
I would encourage you to ask them specifically because I wouldn't have knowledge of that, whether they did or didn't know that.
So when you signed these, you were signing them without knowing whether or not a appointed governor's director of a state agency, and they may have not known that when this person was terminated or left state government and signed this confidentiality agreement, and that the money that they were being paid of, some of it possibly coming from within their budget, you were aware of, but they weren't?
I was approving the signing of these documents. I didn't sign all of them, but they could not be signed unless they were approved by my office. So many times that was a call from the labor relations specialist explaining what the settlement was, why they had determined to settle it, and I would give them a verbal approval. They weren't all signed by me. I am not in a position to tell you exactly what each department director knew or did not know with regard to those terms and conditions. Again, I would encourage you, if you need that information, to talk specifically and directly to those directors.
Okay. And who actually crafted and
approve the documents that created the confidentiality?
That depends a lot on